I wanted to drop a quick video blog post concerning a January 22nd, 2019 Bloomberg Law article titled "Death to Scabby, Trump's Labor Council Wants Protest Icon Deflated." And it seems that this article has spurred a bit of hysteria, some claiming that it's going to forever trample on workers' speech rights, that it's going to decimate unions. So the article is about the NLRB's decision out in Region 13 in Chicago to bring an unfair labor practice charge against the operating engineers for their use of the ubiquitous inflatable union rat at a construction site. And specifically what it relates to is whether or not the usage of a large inflatable rat violates Section 8B4 of the National Labor Relations Act. So if any of you have ever read my blog, I talk a lot about Section 8B4 of the National Labor Relations Act, which is also known as the secondary boycott provision of the National Labor Relations Act. But if you haven't read it, what Section 8B4 prevents or prescribes is the union's coercion, restraining, or threatening of an individual or a business where the object is to have that business or person stop doing business with another. So how does that work? Say in the construction industry, the union will engage in some sort of conduct directed at a construction owner or a general contractor, where the object is to have a non-union contractor utilized, a non-union contractor replaced with a union contractor. And when you see a construction site where the inflatable rat is present, you know that a non-union contractor is on that site, and the object of the union is to see that one of their signatory contractors replaces that non-union contractor. So now, under a federal statute, if a union engages in conduct that violates 8B4, they can be subject to money damages if they cause harm to anyone, in monetary harm to anyone. But in this case, the NLRB is seeking an injunction against the union for its uses of a union rat. So it's not about workers' speech, it's about the uses of the union rat. And what's important is the union in the Chicago case is alleged to have placed the union rat near the entrance of the facilities where the work was being performed. And the question before the court is whether or not the placement of a union rat near the entrance of a facility is coercive within the meaning of 8B4. Now, when you look at the phrase of what kind of conduct is prescribed by a union, it's conduct that threatens, coerces, or restrains or another. That's pretty broad, it's pretty ambiguous. And the courts and the board have attempted to define the contours of what conduct falls within the meaning of that phrase. Now, on one end, the Supreme Court has said that peaceful conduct like handbilling, where somebody is handing out a flyer on a street to somebody that walks by that says, hey, there's a union contractor here or a non-union contractor here, you should know about it, and we urge you to contact whomever and ask them to replace that contractor with a union contractor. What the Supreme Court has said is that conduct is not threatening, it's not coercive, it's not restraining within the meaning of 8B4, and probably is protected free speech. Now, on the other end, you have traditional picketing. And traditional picketing, the courts have defined as somebody with a sign on a stick that's patrolling in a controlled fashion around the entrance of a facility. And the courts and the board have said that that type of conduct can be prescribed, and that type of conduct can violate Section 8B4 of the National Labor Relations Act. And in between, you have everything else. And now, the article on Bloomberg and the articles that have followed it have set up this unfair labor practice charge that Region 13 is pursuing as this battle between the First Amendment and Trump's labor board. And that's just simply not the case. What this case is about is conduct. And courts have always differentiated between speech and conduct. In fact, if this case involved the union driving around in the sound truck at 4 a.m. blaring its grievances to anyone that's awake at that time, nobody would probably say boo. But in this case, the conduct is the placement of a rat, and specifically near the entrance of a facility. Now, the general counsel, who's representing the National Labor Relations Board, is arguing that the display of the union rat near the entrance of a facility is conduct that falls outside of the First Amendment protection, and is conduct that falls within the type of conduct that is prescribed by Section 8B4 and is in fact tantamount to picketing. And on the other hand, the union has argued that the display of the rat is pure protected speech. Now, again, despite what the article would suggest, the arguments that are before the court in this case are actually not novel or new, and the district court, depending on how it decides, if it decides in favor of the general counsel, is not breaking any new legal ground. In fact, the 11th Circuit, which covers Alabama, Georgia, and Florida, has already said that the display of a union rat near a facility in close proximity to its entrance can be coercive within the meaning of Section 8B4 and can be the subject of an unfair labor practice charge, and can be something that the National Labor Relations Board can take action on to stop a union from engaging in. Now, it also needs to be clear, because it's not clear from the article on Bloomberg Law, is that if the union wanted to display this union rat down the street in a public park and to advertise to anyone that walks by this public park that, hey, in this city there is a firm that's hiring non-union contractors, and in our opinion that's causing a whole host of problems, the general counsel would be powerless probably to stop the union from engaging in that type of conduct. And frankly, most government agencies couldn't stop the union in engaging in that type of that type of conduct. Again, the narrow question before the court is whether the union's display of the union rat near the entrance to a facility is coercive. Now, we'll have to see what the court decides. If the court does decide that it is coercive, that's going to have tremendous implications for owners and general contractors that have either mixed construction sites or all merit shop construction sites, because if the union, depending on where that union rat is situated, displays that union rat, they can in fact be found to be violating Section 8B4, and an unfair labor practice charge can follow. Now, if the court were to rule against the National Labor Relations Board and say this is pure First Amendment speech, we can be certain that there's going to be appeal to the Seventh Circuit, and probably eventually up to the Supreme Court, because at that point there is a conflict in the circuit. You have the 11th Circuit, like I said, and you'd have the 7th Circuit holding one thing and the 11th Circuit holding another, and that's where, in those instances where you have a conflict in the circuit, that's where a lot of times you see a Supreme Court take up an appeal. But that's it for now. If anyone has any more questions about the confines of Section 8B4, what a union can and cannot do when it's engaging in a labor dispute, you can always reach out to me, Wally@zimmalonglaw.com, and all my contact information is available on my blog. So take care.